Welcome to our dive into the fascinating world of Cameroonian law. At its heart, Cameroon operates under a truly unique mixed legal system. This means it skillfully blends elements from French civil law, English common law, and also incorporates deeply rooted local customs. Think of it as a rich tapestry woven from different legal traditions. Now, towering above all other legal instruments is the Constitution, specifically the 1996 and 2008 versions, which stand as the supreme law of the land, dictating the framework for everything else. But where does law actually come from in Cameroon? Well, its key sources include legislation passed by Parliament, international treaties that have been ratified, persuasive judicial precedent, meaning decisions from higher courts, and, of course, recognized customary law. Understanding this blend is absolutely crucial for any HND student, as it forms the bedrock of the entire legal framework. Moving on to criminal offenses, Cameroon's penal code adopts a very structured tripartite system for classifying crimes. And this classification is super important because it directly impacts the severity of the penalties, the procedural steps involved, and even which court has the jurisdiction to hear the case. At the top, we have felonies, or crimes as they're often called. These are the gravest offenses, carrying the heaviest sentences, and they are typically tried in high courts. Next, we have misdemeanors, or delites. These are intermediate offenses, less severe than felonies, but more serious than the last category. They're usually heard by magistrates' courts and carry moderate penalties. Finally, we have simple offenses, or contraventions. These are the minor infractions, the least serious, and are processed by courts of first instance, usually resulting in small fines or very short imprisonment. So, remember, understanding this tripartite system is key to grasping how justice is administered in criminal matters in Cameroon. Now, let's talk about something fundamental to identity and rights: acquiring Cameroonian citizenship. This is a core concept for every HND student to grasp. There are two primary methods for becoming a Cameroonian citizen. Firstly, citizenship can be acquired by birth. This adheres to specific principles outlined in national law, namely jus soli, which is the right of soil, meaning if you're born within Cameroon's territory, you might be a citizen, and jus sanguinis, the right of blood, meaning if one or both of your parents are Cameroonian citizens, you might acquire citizenship regardless of where you were born. The second main method is through naturalization. This pathway is for individuals who wish to become citizens after fulfilling certain legal residency requirements and other stipulated conditions, demonstrating their integration into Cameroonian society. Remember, acquiring citizenship isn't just about a passport. It entails fundamental rights and, importantly, significant obligations towards the nation. Next up, let's shine a light on the crucial role of Cameroon's parliament, primarily the National Assembly. It performs two absolutely vital functions in the nation's governance. Firstly, and perhaps most obviously, it's responsible for lawmaking, or legislation. This means it debates, amends, and ultimately enacts proposed laws, known as bills, into binding statutes that form the country's legal framework. This is how new rules and regulations come into being. Secondly, and equally important, Parliament exercises oversight of the government. It holds the executive branch accountable, scrutinizing its actions, policies, and budgets to ensure transparency and adherence to national interests. This oversight function is a critical aspect of good governance, ensuring that power is not abused and that the government acts in the best interest of the people. Let's explore the dual pillars of citizenship: human rights and citizen obligations. Human rights are incredibly important. They are inherent and universal entitlements, meaning they belong to every individual simply by virtue of being human. They apply without discrimination, regardless of who you are or where you come from. But citizenship isn't just about rights. It also comes with essential obligations towards one's nation. These obligations are crucial for maintaining societal order and fostering national development, a core component of any citizenship education program. Key among these obligations is strictly obeying the laws of the country. This isn't just a suggestion, it's vital for upholding social order and ensuring a functioning society. Another critical obligation is diligently paying taxes. These taxes are not just numbers, they fund vital public services, education, healthcare, and infrastructure, which are essential for national development and the well-being of all citizens. Now, let's shift our focus to the realm of philosophy, specifically normative ethics. This is a crucial branch of moral philosophy, and its main purpose is to establish clear criteria or principles for determining what constitutes right and wrong conduct. Unlike descriptive ethics, which simply observes what people believe is right, normative ethics actively seeks to develop and defend theories about how individuals and societies ought to act. It's essentially about building a framework for moral decision-making. This field delves deep into exploring various principles, rules, and virtues that can guide the evaluation of good and bad behavior. Ultimately, normative ethics forms the very basis for the ethical standards we uphold in society, providing a structured way to think about and implement morality in our lives. Let's talk about employment contracts, a key topic in labor law for HND students, and how they're primarily distinguished by their duration. First, we have a contract of specified duration, commonly known as a fixed-term contract. As the name suggests, this contract has a clearly defined start and end date, or it's established for the completion of a very specific task. Crucially, it automatically terminates upon its conclusion. There's no ongoing expectation beyond that point. On the other hand, we have a contract of unspecified duration, or an indefinite term contract. This type of contract lacks a predetermined end date and continues indefinitely until it's lawfully terminated. Termination in this case can occur through various means, either party giving due notice, an employee's resignation, dismissal for cause by the employer due to serious misconduct, or even by mutual agreement. It's important to remember that the termination methods differ significantly between these two types, and understanding this distinction is vital for both employers and employees. Continuing on the theme of employment, let's explore the various legal avenues through which an employment contract can be brought to an end. These methods reflect the diverse circumstances under which the employer-employee relationship may conclude. Firstly, for fixed-term contracts, termination can occur automatically upon the expiration of the specified duration. It simply runs its course. Secondly, an employment contract can end through mutual agreement, where both the employer and the employee voluntarily consent to terminate the relationship. This is often the smoothest way. Thirdly, an employee may initiate termination by resignation, provided they give due notice as stipulated in their contract or by law. And fourthly, an employer might implement dismissal for cause. This happens due to serious breaches of contract or gross misconduct by the employee, and in such cases, it can often occur without notice or severance as permitted by labor law. Understanding these different pathways is crucial for managing employment relationships effectively and legally. Let's turn our attention to a fundamental concept in business law, the discharge of contractual obligations. A contract's obligations are discharged when they are brought to an end. The most common and ideal method is by performance, where both parties fully and accurately fulfill all their agreed-upon terms, completing the contract as intended. However, discharge can also occur by agreement. This means the parties can mutually cancel the contract, replace it with a new one through what's called novation, or simply waive certain terms. Then there's discharge by breach. If one party commits a significant breach, the innocent party can treat the contract as discharged and sue for damages. What about unforeseen events? That's where discharge by frustration comes in. If unexpected events make performance impossible or radically different from what was initially agreed, the contract can be discharged. Finally, obligations can be discharged by operation of law, meaning legal principles such as bankruptcy automatically end the contractual relationship. Finally, let's explore the key OHADA company structures available in Cameroon, which are defined by the OHADA Uniform Act on Commercial Companies and Economic Interest Groups. First, we have the Société Anonyme, or SA. This is your public limited company, typically used for large businesses looking to raise significant public capital. It offers limited shareholder liability, but comes with strict regulations. Next, the Société à Responsabilité Limitée, or SARL, is incredibly popular for small and medium enterprises. It also provides limited liability to its members, but boasts a much simpler formation process. For those seeking flexibility, the Société par Action Simplifiée, or SAS, is a fantastic option. It provides limited liability, has no minimum capital requirement, and allows for highly customizable governance, making it ideal for startups and innovative ventures. Lastly, the Société en Nom Collectif, or SNC, is a general partnership. Here, partners bear unlimited joint and several liability, meaning their personal assets are at risk. This structure is typically chosen by those with high mutual trust among partners.